Hello everyone, my name is Satyam Shivaach and I am working as a legal intern with LEXIS and Company. And in this video, we will discuss about different types of director in a company law. Director is defined under Section 234 of Companies Act, which defines a director means a director appointed to a board of company. The responsibility of director is primarily consist of determining the company's strategic and objective and policies. Moreover, the monitoring progress towards achieving the objective and policies. Next being the appointment of senior management, and the last being the accounting of company's activity to relevant parties. Now, what are the minimum directors which are required in a company? In a one-person company, minimum of one director is required. In a private company, minimum of two directors are required, and in a public limited company, minimum of three directors are required. Maximum 15 directors can be appointed in any of the format of company, but by passing a special resolution, we can increase the number of directors beyond 15. And out of all the directors, one of the directors should be a resident of India and have stayed more than 182 days in the last calendar year. Now let's see the types of director. Starting with the residential director. As per section 149 clause 3 of the Companies Act, every company shall has at least one director who has stayed in India for a total period of not less than 182 days in the previous calendar year. The second is the independent director. Independent director are the non-executive director of a company and helps the company to improve corporate credibility and enhance the governance standard. In other words, an independent director is a non-executive director without a relationship with the company which might influence the independence of his judgment. The tenure of the independent director has a whole of 5 consecutive years. However, they can be entitled to reappointment after passing a special resolution with a disclosure to the board report. The following company need to appoint at least two independent directors, which are public company which is having a paid up capital of 10 crore or more, or a public company which is having a turnover of 100 crore or more, or a company which is having a total outstanding loan, deposit and debenture of 50 crore or more. Now the next type of director is small shareholder director. A listed company may have one director elected by small shareholders. They may be appointed upon the notice of not less than 1000 shareholder or 1/10 of the total shareholder, whichever is lower. Having a small shareholder director which is elected by the small shareholder, and the director will represent these small shareholder in the board. Now the next is women director. As per section 149 clause 1 subclause A provides the provision which requires certain categories of companies to have at least one woman director on board. Such companies are the listed company and any of the public company having a paid up capital of 100 crore or more, or having a turnover of 300 crore or more. Now the next is additional director. Any individual can be appointed as additional director by the company under section 161 of the new act. The next being the alternative director. As per section 161 clause 2, a company may appoint if the article confers such powers on company, or a resolution is being passed. If a director is absent from India for at least 3 months, an alternative director can be appointed. An alternative director cannot hold the office longer than the term of the director in whose place he has been appointed. Additionally, he will have to vacate the office if and when the original director returns to India. Any alternation in the term of office made during the absence of the original director will apply to the original director and not to the alternate director. Now the next is shadow director. A person who is not appointed to the board but on whose direction the board is accustomed to act is liable as a director of company unless he or she is giving advice in his or her professional capacity. Now the next is nominee director. They can be appointed by certain shareholders, a third parties through contract, or by lending public financial institution or banks, or by central government in case of operation or mismanagement. These type of directors are appointed by the big financial institution so that they can monitor and put their stake in the board to enhance the productivity of the company. Now let's see the difference between executive and non-executive director. An executive director can be either a whole-time director of a company, means one devotes his whole time of working hours to the company and has a significant personal interest in the company as a source of income. Or a managing director is one who is employed by the company as such and has a substantial power of management over the affairs of the company, subject to the substantial direction and the control of board. In contrast, a non-executive director is a director who is neither a whole-time director nor a managing director. That is all for today's video. Thank you for watching. Please like, share and subscribe.